Alright, guys, buckle up. We're jumping right into chaos as this repeat offender waltzes back into Judge Middleton's courtroom like she owns the place. Right away, you can feel the tension rise. She's barely seated before she starts pushing her luck. The judge, clearly remembering her previous antics, wastes no time reminding her who's in charge. It's not just about court etiquette anymore. This is a ticking time bomb of disrespect. She acts like this is just a casual meetup, not a criminal hearing. If you thought she learned her lesson last time, think again. This is going to get messy.
Are on the record in case number 2024 TR 617, State of Kansas versus Abel Estrada Jr. Paulie Dean for the state. This is 2024 TR 617. Mr. Abel, you need to start your video and audio. Mr. Abel, you need to start your audio and video so we can have your bench trial.
Here. Hello, here. Hello? Hello?
Mr. Abel, you need to start your audio and video. Sounds like you've started your audio.
Yeah, the video. Start video. Okay.
All right, Mr. Abel, you are representing yourself today, is that correct?
Yes.
Okay.
Judge, you never approved my order for withdrawal.
Yeah, you set that over for today.
Well, I do have your motion to withdraw. I also have the defendant's pro se motion to dismiss with extreme prejudice, affidavit of true and affidavit of reservation of rights request for writ of discovery, which he filed November 21st to 24. Mr. Abel, what's going on between you and your attorney? Do you want an attorney or do you not?
I do, but he's not able to defend me because for the interest, I don't know, but he's not defending me. I need an attorney.
You say you need an attorney?
But you know,
I don't know if it's your computer or mine, but I'm having a hard time hearing you, sir.
hello.
Just see, is that his computer or mine?
I hope it's not mine.
He's not sitting close enough to the microphone, Judge.
All right, you need to sit closer to your microphone is what I'm told, sir.
Can you hear me now?
That's great, yes. Now, what's going on with your attorney? Do you want your attorney or not?
I do, but there's some conflict of interest where he said he's not going to represent me.
He says he's not going to represent you?
He says he's going to pull himself out.
Okay, Mr. McClendon, what's your take on this?
Judge, my client wants me to support a position that I believe is contrary to the Constitution of the United States. And I took an oath to uphold that when I became an attorney, and I take that oath every year. And he's wanted me to pursue this position that I do not feel comfortable representing the law.
Your Honor, this is the same issue. I believe Mr. Paul was first appointed to this case. Essentially, the defense, as the court has seen, is one that's contrary to the United States Constitution of the state of Kansas, that he's, for some reason, is exempt from, as a private citizen, on the laws of the state of Kansas.
Well, aren't we going to have the same problem regardless of what attorney he has?
That's correct.
Judge Middleton is visibly done playing games. From the moment this woman tries to overtalk him, it's crystal clear. His patience is already paper thin. You can see it in his posture, hear it in his voice. This isn't a courtroom anymore. It's a test of restraint. She's pulling the classic sovereign citizen maneuver, throwing in irrelevant statements and dodging direct questions. But the judge isn't having it. His tone sharpens. The bench is not a playground, and today, he's here to remind her. One more word out of place, and she's going to feel the full weight of the court come crashing down.
And if my understanding is correct, the court has indulged Mr. Abel in that it's appointed him 2 attorneys now. 2 attorneys he's sought to have basically present a defense that's contrary to the Kansas Constitution, contrary to the oath that each attorney takes when they're licensed by the state. And additionally, this carries a maximum sentence of 30 days, which would typically not even make him eligible for an attorney, but the court has taken the effort to give him counsel.
Well, and didn't Mr. Estrada, didn't this attorney, William McClendon, represent you when this was brought in initially in city court?
Yes, and it was dismissed. This is why I'm claiming double jeopardy, because I'm going for the same case over again, and this has been dismissed already. Why am I going to court again?
Well, you didn't actually go to trial in the other one. You had a first appearance, as I recall, and then it was dismissed. So you haven't had any jeopardy attached. You've not had a trial in this.
Well, the supremacy laws says that you cannot be tried or convicted of anything.
I know what they say. All right. Well,
Listen to your words, sir. You just stated it. Tried or convicted. The jury was not impaneled. The judge had not begun to take evidence in your city court case. It was dismissed. Jeopardy does not attach until one of those events occurred, and they have not occurred.
So Mr. Abel, if you want an attorney, it's going to be William McClendon. If you don't want an attorney, you'll have to either hire one, which it's kind of late for that in the day, or you'll have to represent yourself. So which way do you want to go?
I like to get an attorney, but
I'm not going to give you continuance for it, because you've had this case in municipal court, you've had this case in this court, you've known this hearing was coming up, and you've gone through 2 attorneys. So what do you want to do? Are
very
you going to
simple.
represent yourself or use Mr. McClendon? Those are basically your choices.
I want to be, but the
You
paperwork
have to stay up by the microphone. I can't hear you.
I want to be represented by my attorney, but the paperwork that I put in there is completely lawful, and he doesn't want to go forth with my
Okay.
paper.
So here is that where the disagreement is? You filed this voluminous motion to dismiss with extreme prejudice, as you captioned it, and he doesn't want to argue that for you? Is that why you 2 are in disagreement?
Yes.
Amongst many other reasons.
The more she talks, the deeper she digs. At this point, it's almost painful to watch. She's not just arguing, she's actively sabotaging herself, minute by minute. The judge gives her multiple chances to correct her tone and behavior, but nope, she doubles down on defiance. Instead of defending herself legally, she's putting on a show that only adds to her charges. It's like watching someone burn their own parachute mid-fall. Her attitude is toxic, her logic non-existent. This isn't a courtroom defense, it's a public self-destruction, broadcast live.
I'm going to...
The judge, if he's able to draft a motion of such, I don't see why he can't be able to argue it himself.
Well, I'm going to have you stay on board, Mr. McClendon. And Mr. Abel, I have read your motion. Believe it or not, I did read it all. I read about your arguments for the Sixth Amendment right to counsel and your discussion of Attorney Richard Paw having a case conflict. And then you start talking about your commercial and private license plates. You start citing federal law that isn't even applicable here.
How's that?
You start getting into the U.S. Code. You start talking about retaliation and coercion and the right to confront witnesses, which I agree you do have, and they are here to testify, as I understand it. But I don't agree with this, what you call lawful private American righteous onto the Lord, the King of glory, and the law of the land of the United States, ex parte Milligan. That isn't even making any sense. You start talking about military courts. This is not a military court. You start talking about being a free person, having the right to travel on the roads. Well, provided by their servants for that purpose. Well, we don't have servants in that sense. People are not servants unless they're hired and appropriately contracted. But as far as the roads, if you don't see yourself as having contributed to making those roads, you have to go by the rules of.
She finally tries to slip an emotion, and Judge Middleton shuts it down with surgical precision. It's not just denied, it's dismantled piece by piece. The judge breaks down exactly why her request has no merit, and you can see her spirit wobble a bit. But rather than take the L quietly, she starts another tirade, still convinced the court is somehow out to get her. This isn't justice denied, it's justice refusing to be mocked. Middleton makes it abundantly clear, he's seen this circus before, and he's not buying another ticket.
Your paperwork, you've included the order of dismissal from city court. You argue that the U.S. Supreme Court and other high court citations prove that no license is necessary for normal use of an automobile on common ways. That's not right. That's not the law. You talk about yourself being a traveler on foot, but you weren't a traveler on foot using the public highways. You were driving a motor vehicle, according to the allegations. You attached something from a Nora Weisenberg Foreign National Division, and you addressed Governor Pat McCrory out of Raleigh, North Carolina, a 2015 letter with a carbon copy to Deputy Justice Attorney General Loretta Lynch and Secretary of State John Kerry. I don't see that having any relevance or bearing. Then you've got something with a copyright number and a fee schedule with lawful legal notice, as you call it. And you start talking about prohibited actions in 18 U.S.C. 101, 18 U.S.C. 241, and you go down through those. And again, this is not a federal court. And then you start talking about you have fees that the officers must pay before they can do any business with you.
Correct.
And if they refuse to pay your fees, then any business or interaction with them or transaction you say is basically void. And I do not find that that is the law. You have an interesting fee schedule attached. Apparently, to give them your name, you charge $50,000.
Correct.
To give your driver's license number, you charge the officers $50,000. If they want your social security, it's $100,000. If they want a retinal scan, is that $5 million?
That's correct.
Fingerprinting, photographing, $200,000 each. Then DNA and a bunch of that stuff is $5,000, and you go on with like a long list of what you're going to charge them with, or charge them for talking.
Now she's flailing, legally and emotionally. Instead of presenting a coherent argument, she's tossing out buzzwords and half-baked legal theories like confetti. You'd think after getting smacked down 4 times in 10 minutes, she'd regroup, but nope. She leans into the absurdity, almost daring the judge to react. But Middleton, ever the professional, keeps the courtroom steady while delivering brutal truth bombs. This isn't a debate. It's a clinic in how not to behave in front of a judge. And everyone watching knows, she's the punchline in her own courtroom comedy.
And I'm not going to honor that fee schedule because I don't think that has any law in this court, any bearing in this court. You either have the right to talk to the officers or you have the right not to talk to them. You have the right to talk to them with your attorney, again, or you just have the right not to talk to them. But to try to charge them these fees, that is not consistent with the law. And then you have a document, the 12 presumptions of court, and you start talking about a Roman court does not operate according to any rule of law, but by presumptions of law. You go on to talk about before a lower Roman court and a private bar guild. You talk about presumptions of public oath to the bar guild. And again, this is not a practice that Kansas uses. So I'm not going to make any rulings in favor of that document.
But it's a violation of my rights, because what you do with 39 CFR subsection 3(9).
Okay, I can't hear you, sir. You're going to have to get in front of the microphone.
I've been in front of the microphone, but what you're saying is a clear violation of my rights, because 49 CFR subsection 3(0).
All right, well, sir, I'm going to stop. I'm going to stop you there. You've argued your point very, very extensively in your written documents. So I've heard your arguments in the written documents. I don't see any basis to them in this case, and I deny all of your motions and arguments. I note your objection for the record, so you can appeal if you wish, sir. But as judge in this case, I'm denying your motions. And we're going to proceed with your bench trial on a factual basis.
Yeah, but under what law are you basing this? What law? Because you're violating the
Under
law.
the Kansas laws. And if you don't know the Kansas laws, that's what you have an attorney for. He knows the Kansas laws. So we're going to proceed. We're going to proceed, sir. You need to restrain yourself a little bit. We have an orderly process we go through. Mr. Dean, are you ready to proceed?
State's ready, Your Honor.
All right, please call your first witness. And for the record, we are looking at a bench trial on the charge of vehicle display of a license plate. There's an argument. Okay. Yes, sir. Briefly.
The privacy clause, Article 6 of the Constitution, it says that the law of the land, the supreme law of the land, is the Constitution.
All right. I'm denying your motion, sir, and you need to. If you're gonna participate in this hearing, you have to get closer to your microphone.
I'm on top of it. Literally, my face is on the microphone.
Well, you have to turn it up somehow. All right, Mr. Dean, if you'll call it, we're going to start the trial. Are there any opening statements?
Statement waive open statements. Looks like we have Deputy Hanson here with us.
Deputy Hanson, please raise your right hand. You solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Very well. Please proceed, Mr. Dean.
Deputy Hanson, would you please state your full name and title?
I am Deputy Clinton Hanson of the Greenwood County Sheriff's Office.
And how long have you been so employed?
Since June of 2023 at this agency.
And how long have you said at this agency, have you worked at other law enforcement agencies prior to your employment with Greenwood County?
Yes, sir. I have a grand total of 15 years in law enforcement.
And is that the same amount of time that you've been a certified law enforcement officer?
Yes, sir.
And back on August 21st of 2024, what were your duties on that day, sir?
On that day, I was just assigned to general patrol and any service calls or accidents that came up.
And were you patrolling the city of Eureka in Greenwood County, Kansas on that day and time?
Yes, sir.
And was there anything on that date that caught your attention as odd?
Yes, sir, there was.
And what was that?
While I was southbound on Main Street, I stopped at the stoplight and I noticed the vehicle in front of me had a very unusual registration on their vehicle.
And what was unusual about that registration?
Well, in 15 years of law enforcement, while I understand things change with license plates, I had never seen this license plate before. What also became very apparent to me as odd was the fact that it had a Kansas label on it as well as a US DOT.
I'll show you what I marked as State's Exhibit number 1. I believe you have the possession of this at the Sheriff's Department, correct?
I do, sir, it's right here.
And that's a license plate that you removed from this vehicle, preserved for evidence for today. Is that correct?
Yes, sir. Yes, sir.
And does this appear to be an accurate picture and representation of the plate that you observed while you were on routine traffic patrol back
Yes,
on
sir.
August 21st, 2024?
Yes, sir.
And that's what you're referencing, Kansas and US DOT, not appearing to be something that you would normally see as far as the layout of a license plate.
Correct.
Is private something you generally see on a license plate?
Not a plate that has ever been issued, to the best of my knowledge, by the state of Kansas or any other state.
Did you attempt to run this license plate before initiate or while you were investigating this matter?
I did.
And what, if any, information was dispatch able to provide to you?
There was no information. We could not get a what we call a return or a return from the state with all of the vehicle information.
Kansas, a lawful Kansas license plate, would it not also show a month that it expires and a current sticker showing that it's been registered, tags and taxes paid?
Yes, sir, in the upper right-hand corner.
And that's where it's just indicating that it's exempt for some reason.
Yes, sir.
Based upon the observations of State's Exhibit number 1, Your Honor, and I would move for admission of the same. He's identified it.
Any objection to admission of State's Exhibit 1? Hearing no objection, State's 1 is admitted.
I didn't say anything. I'm trying to.
Things hit a boiling point. Her voice rises, her interruptions multiply, and her attitude? Pure poison. At this point, she's treating the courtroom like a stage and the law like a joke. But the judge doesn't flinch. Instead, he starts talking over her, a clear signal that her antics are officially irrelevant. You can almost feel the gavel getting heavier in his hand. She's turned a hearing into a circus, and the judge is about to shut it all down. She thinks she's making a point. But in reality, she's just making Middleton's job easier, and her sentence harsher.
Hearing no objection, State's 1 is admitted.
I didn't say anything. I'm trying to speak.
You didn't say anything. That's what I said. But since you didn't announce an objection, I thought you didn't have one.
I do, but I'm trying to speak, but you can't hear me. Anyways, my objection to this is I am completely lawful and I'm following the law of the United States. And I have 2 plates. I have the commercial plates and I have my private plates. I violated no law by that.
All right. Well, your objection is noted, and it's overruled, and we will proceed.
And just to clarify, Deputy Hanson, that was the plate, the only plate that was being displayed on the vehicle that you were observing, correct?
Yes, sir.
After viewing that and having dispatch run the numbers and nothing coming back, what did you then do?
For a short time, I had to disengage from the vehicle. We had another 911 call. I was later able to find the same vehicle and observe a traffic violation as he was leaving the city of Eureka, at which time I initiated a traffic stop.
And was that on East River Street?
The traffic violation was on East River, like a block inside the city limits. So by the time we actually came to a stop, we were in rural Greenwood County.
And what was the traffic infraction that you observed at that time prior to the stop?
Illegal usage of a lane or an illegal lane change. He was in a right-hand turning lane and failed to signal moving left into the appropriate lane, leaving the city of Eureka.
So after making that observation, I think you were starting to say, perhaps you already said you started the traffic stop, is that correct?
Yes, sir.
And did you make contact with the driver?
I did.
And do you see that driver with us here today?
I do, sir.
And where is he?
He is the man wearing glasses listed as Abel E.
Your Honor, to ask the record to reflect that the officer has identified the defendant.
The record shall so reflect.
Were you able to identify Mr. Abel, who you've identified as Abel E, when you contacted him for any type of identification?
I did, sir.
And what did he provide you?
Upon initial contact, he provided me with his valid Kansas driver's license. There was some other paperwork that was inconsistent with what I normally see on a traffic stop as far as registration. He also did provide me current valid insurance.
All right. So, based upon the information he provided to you, what did you then do?
Some of the statements that he had began making, I had recognized through some training with the sovereign citizen movement. I'm not claiming that he is, just I have heard that in previous encounters and training. So feeling that at some point a supervisor would be requested by Mr. Estrada, I went ahead and requested a supervisor. And then I went back and ran the vehicle's VIN number through my in-car terminal, and I was able to get actually what the vehicle was.
And this was a 2011 GMC Acadia, is that correct?
Yes, sir.
And in regards to the, did he make any statements to you in regards to why he was displaying this tag?
Because he said he was driving in the private, he was not driving commercially. He did not he did not need a commercial license plate. That, according to him, the plate that was displayed was perfectly legal and lawful.
And he indicated he was returning or had returned the Kansas registration plate.
He said he was getting ready to, and he actually held up the envelope that he had packaged up and ready to drop in the mail. The standard Kansas license plate, he was going to mail it back to Topeka.
Did he make a statement that he was a free national and that's why he was going to use his own private plate?
Yes, sir.
Okay, Mr. Abel, we probably ought to clear this up. I did not let Mr. McClendon off the hook, but are you going to use him as your primary counsel, or do you want to represent yourself? Because I can keep him back here in case you need him and let you proceed, but I need you to tell me whether you're going to let him represent you and take the lead on this, or if you're going to stay in charge of it.
Well, I like to get him to represent me, but none of the work none of the paperwork that I put in there, he wasn't represent. Secondly, you guys are violating my rights because this officer is literally lying on the stand, because I presented all my documents, and just because he never seen it doesn't mean that it's not real. And also, it's from the DOT. It was assigned to me from the DOT as a private citizen, and you never let me read the law. 49 CFR subsection 3903. It says general applicability section. Applicable only to employers and employees of commercial motor vehicles that transport property, passengers, in the interstate in commerce. I am not in for profit. I'm not for profit.
All right,
I am not.
so excuse me, sir, I take it that Mr. McClendon is not going to be primary counsel on this. You're going to represent yourself primarily, is that right?
I want to help me, but he doesn't speak. He doesn't say nothing. He's not defending me. I'm defending myself.
And there it is, the contempt warning. Judge Middleton's tone flips from firm to fire. You don't get many more chances after this. She's now interrupting every sentence, refusing to answer even the most basic questions. And when she does talk, it's nothing but deflection and drama. The judge doesn't yell. He doesn't have to. His calm is scarier than shouting. That cold, final warning tells us everything. This isn't just a bad hearing anymore. It's heading toward legal disaster. If she wanted attention, she's about to get the kind that comes with handcuffs.
But you see the law differently. You're wanting to argue differently than the law that applies to the court we're in.
Your Honor, I didn't even hear an objection lodged in that statement. I'd ask the court to overrule whatever it is that he's just stated so we can move on.
All right. Well, I do overrule any objection that you were trying to make because, frankly, I didn't totally understand what you were trying to say, but what I did understand has no bearing on this case. But Mr. McClendon, I guess he's just going to take charge, and you're going to just sit there, and if he needs you, he'll let you know.
Your Honor, I'd ask the court formally recognize Mr. McClendon as standby counsel.
That is how he is recognized. Just stand by counsel.
Thank you, Your Honor.
You're welcome. Go ahead, sir.
Your Honor,
No, I mean Mr. Dean.
You guys are violating my rights, my constitutional rights.
All right. I note your objection. I can't hear you now. You're not making a very good record, but I understand you object. I've overruled it, and you can argue that with the Court of Appeals.
Under what law? Are you under what law?
Well, if you think I'm violating the law, then you take it up with the Court of Appeals if you lose.
I am not gonna, because I'm righteous unto the law. The law says that I have to be in commercial, and I'm not in commercial.
All right. Well, you can argue that in your closing argument. Go ahead, Mr. Dean. Overruled, and you can argue it on appeal if you need to.
That is a violation of my rights.
I note your position, sir.
You're violating my rights blatantly.
Sir, you've made your point. I've ruled against it. You need to let Mr. Dean proceed. Sir,
you're railroading me.
Well, sorry you see it that way, but you need to stop talking now and let Mr. Dean proceed with his evidence.
What evidence? They're false.
Stop, sir. Go ahead, Mr. Dean.
I believe the question I'd asked is if he indicated that, I think you answered that he said he was free national sitting back his Kansas registered for his Kansas license plate.
Objection.
All right, Deputy, you want to answer the question?
Well, he stated objection again, not a basis. I don't know if the court wanted to rule.
Well, it's hard for me to rule when he keeps cutting in and out. I can't hear what he's saying. All right.
Unbelievable.
What's your objection this time?
That I have a recording, and what the officer is saying is incorrect. I never said.
Then you can bring that up on cross-examination or in your own testimony.
It's what we call cross-examination, sir. Deputy Hanson, following those statements and that information he provided to you, what did you then do?
Real quick, Mr. Dean, do you want me to answer that other question?
Yeah, go ahead and answer that question. We've kind of gone off on a tangent here. Excuse my reference, Your Honor. So I'm not sure whether you got that answer out or not, but go ahead and answer, please.
He did not tell it to me directly. He was speaking with Sergeant Michelson, and I overheard it.
Okay. And at this point in time, did you then just simply issue a citation for the illegal display of a tag?
Yes, myself and another deputy removed the license plate that you had shown me a picture of. We then put on the license plate that he was getting ready to send back to Topeka, and I issued him an NTA for the illegal tag.
And this all occurred in the within the corporate limits of Greenwood County, Kansas. Is that correct?
Yes, sir.
Your Honor, I don't believe I have any further questions or evidence. The court's admitted the photograph of the license plate has been identified. It's been identified. Jurisdiction has been identified.
So the state rests?
State rests.
All right, Mr. Estrada, the state has presented what they're going to present.
I guess technically, Your Honor, my apologies. We don't actually rest yet, Mr. Estrada. I don't know if he's going to